thank you all and welcome to the 38th meeting of the Fair Employment and Housing Council. The meeting is being called to order, and to get us started, DFEH Legislative and Regulatory Counsel Brian Sperber will conduct the roll call.
Chair Mandelbaum.
Present.
Councilmember Brodsky.
Present.
Councilmember Iglesias.
Present.
Councilmember Ortiz.
Present.
Councilmember Sandoval.
Present.
Councilmember Scher.
Present.
Director Kish.
Present.
So thanks for attending our remote meeting. We're being webcast live, and video of the meeting will also be available afterwards on our YouTube channel and website. For those of you who are participating remotely, you may have noticed that you're currently muted and your video is disabled, and that's to allow for a coherent group video meeting. However, as in all of our in-person meetings, of course, there will be opportunities for public comment as we tackle each of our agenda items. And there's a couple different ways that you can provide public comment. You can email the council at fehcouncil@dfeh.ca.gov, and we'll be checking that email account throughout the day. You can also use the Zoom chat feature to chat the meeting administrator, who will read your comment aloud at the appropriate time. Or if you want to speak directly rather than through your written text, you can utilize the raise hand function in Zoom or press *9 if you called in. And you will have the opportunity to provide your comment yourself. If you want to rename yourself on the Zoom list of participants, there's a button to click rename at the options next to your name. There's a number of department staff members we'd like to acknowledge, starting with Adam Romero, the DFEH's Deputy Director of Executive Programs, and the aforementioned Brian Sperber, and a new member of our team, Kara Broadfuhrer, DFEH Legislative and Regulatory Senior Counsel. Welcome to you again, Kara, and us on the council have all had an opportunity to benefit from your insightful comments in the past as a public commenter on behalf of the National Housing Law Project, but some of the members of the public may not be as familiar with you, so do you want to take a chance to introduce yourself?
Thank you. I appreciate the warm welcome, and again, it's super exciting to be here and to be working with the council just in a different capacity. Like Shaya said, I was working previously with the National Housing Law Project, and I engaged with the council quite a bit on different rulemaking actions regarding different housing rights issues, and with NHLP, I also developed a pretty strong expertise in affordable housing. I come with a background also in fair housing, in civil rights litigation. I spent about 8 years in legal services as well, defending unlawful detainers and doing civil rights impact litigation and habitability defense. And I'm very excited to just apply those skills to my new position, and I look forward to working with everybody. So thank you so much.
Thank you,
Welcome.
Kara. So our next order of business is just to review the agenda for today's meeting. Copies of the agenda and the materials for the meeting are available on the council's webpage of the DFEH website, the same page that the live stream video is on, so hopefully you all have found those. Today's meeting will include a public hearing on the proposed housing regulations, a guest speaker presentation on the UNRU Act, revisions to text of the proposed harassment prevention regulations made in response to the public comments we received, and a draft of STIFRA regulations incorporating SB 1383, which was signed into law by Governor Newsom last week. Our first order of business is the approval of our minutes, which is attachment A to the meeting materials. Highlights from our July 27th meeting included a 45-day hearing on the draft regulations addressing harassment prevention, and we also received updates from our various rulemaking and hearing subcommittees. Any council members have any comments related to the minutes? Any public comment on the minutes?
No.
All right. With that, I will move to adopt the minutes.
Second.
All right. We'll proceed with a roll call vote.
Chair Mandelbaum.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Ortiz.
Aye.
Councilmember Sandoval.
Aye.
Councilmember Scher.
Aye.
All right. The minutes are adopted unanimously. Council member reports. Anyone have any reports they'd like to give?
Yeah, I have one. So first of all, just on the hearing, I wanted to thank everybody who organized it. And I just had two quick thoughts. One is that it seemed to me, given all the difficulty that people expressed, there was an underutilization of the Ralph and Bain Acts, but also some suggestions of possibilities of how the department and the council could be helpful in increasing the usefulness and utility of those statutes, including working with local human rights commissions, maybe working with local police departments to let them know that if a victim makes a report, but it doesn't amount to a crime, that it also could be a violation of those acts. Working with Department of Justice to have them funnel, elicit and then funnel complaints to the department. So I think there could be some follow-up there. Additionally, I didn't hear any specific suggestions for regulations to revise those or implement those acts, but there could be some ideas out there. So I do think those might be worthwhile follow-up on the hearing.
Yeah, and we have a subcommittee agenda item later, so I think it might be worth exploring whether we want to form a subcommittee, either the same one from the hearing or a new one, to look at kind of takeaways and potential action items from the hearing.
I think that would be incredibly important. I do think issues that were raised by Councilman Iglesias are something that was reflected by several speakers, but I also think that there are some issues that I wanted to get some more clarification from our expert from San Bernardino, Kelsey San Bernardino, regarding issues of transparency that he raised that I wanted to ask in terms of reporting and those types of matters. It may not be within our jurisdiction, but it'll be good maybe to have a more informed discussion about what in fact that meant with regard to his report.
Great. Any other council member reports? Hearing none, we'll move along to a report from the Greater Department of Fair Employment and Housing. So I'll turn it over to Director Kish.
I just want to highlight one thing which Chair Mandelbaum already mentioned, which is the signing into law of SB 1383, and we'll be hearing more about this today from the subcommittee. But just for folks who are following along, this expands job protected leave under the California Family Rights Act to qualifying employees in workplaces of 5 or more employees, down from 50 or more employees. It replaces the New Parent Leave Act, which extended baby bonding leave to workplaces with 20 or more employees. So now all of the job protected leave available under the California Family Rights Act, including baby bonding leave, is available to qualifying employees in smaller workplaces of 5 or more. It also expands the relationships for which employees can take leave to include non-dependent adult children, siblings, grandparents, and parents-in-law. So I know the council will be taking this up in a bit to amend the regulations to reflect this change, but it's going to be a big change for our smaller employers in the state and for the employees that work there. And stay tuned for more outreach materials from the department.
Thank you.
Thank you, Director Kish. So we are ready for our public hearing on the proposed housing regulations. So let's pivot for a moment to that. So welcome to the hearing portion of our meeting. The purpose of the hearing is to receive public comment regarding the FEHA housing regulations addressing definitions, intentional discrimination, discriminatory notices, statements and advertisements, consideration of income, residential real estate related practices, and disability. This rulemaking action clarifies, makes specifics, and supplements existing state regulations interpreting the FEHA's housing provisions set forth in the government code starting at 12900. Copies of the proposed amendments to the FEHA regulations are reflected in attachment D to the meeting materials, along with the notice and initial statement of reasons, which are reflected in attachments B and C respectively. The materials can be accessed on the council's page of the website, the same page that the live stream video is on. So we're holding this hearing as part of our formal rulemaking process, We noticed the hearing in the California Regulatory Notice Register published on August 7th, and also via email sent to more than 7,500 individuals and stakeholders, and also through the Council's webpage. Pursuant to the notice, we are taking testimony today on the proposed amendments to the regulations. We will also accept written comments on the proposed regulations until the end of today, September 25th. So if you haven't already got them in, please do. You can email written comments to the Council at fehcouncil@dfeh.ca.gov, or if you prefer to mail them, you can do so by mailing them care of Brian Sperber at the DFEH's Los Angeles office, located at 320 West 4th Street, 10th floor, Los Angeles, California, 90013. Anyone who testifies here today or submits written comments will receive a copy of any changes made or amendments that the Council makes, as will anyone who makes such a request. Also, anyone who testifies or submits written comments will have 15 days within which to make additional written comments if any further substantial changes to the proposed amendments are made during the course of this rulemaking process. We'll consider each comment made here today as well as all written comments received, and we'll respond to each of those comments in the final statement of reasons, which will become part of the rulemaking record. The minutes of this hearing as well as all written comments received will also be part of the Council's official rulemaking record. You will not be sworn in before your remarks. However, we do ask that you speak clearly into your microphone and begin by stating and spelling your name and also any affiliation you are making the comments on behalf of. Also, if you are submitting, or if you are commenting rather on a specific portion of the regulations, we ask that you identify this section and subsection so that we can follow along and refer to it as you're giving your remarks. We'll hear testimony until all those wishing to testify have had an opportunity to do so. So without any further ado, we're ready to begin. Is there anyone who has a raised hand or has emailed in a comment or chatted in a comment? I see a couple raised hands.
I'm now going to unmute Janet L.S. Powers.
Good morning. Good morning, Mr. Kish and members of the Council. Janet Powers, Fiore, Racobson Powers. I've appeared before the Council several times, and I'm always here to talk about what I do, which is represent community associations and common interest development. I've submitted written comments to the Council, and I'm sure you'll take those into consideration as you've done in the past. All of my comments reflect the perspective of the common interest developments, condominiums, plan developments, stock cooperatives in California that are subject to the regulations, and so my comments relate primarily to that. I don't have a reason to really repeat what I'm saying in my written comments. I don't want to take the time today. The Council is obviously very busy, and I'm sure you have many people wishing to speak on this topic. I do want to say that I think the regulations are really well written. As usual, I want to compliment the staff and the Council on obviously the time and the effort that was put into this initial rulemaking. My major concerns, again, I'm not going to cite specific sections, relate to associations and the idea that one of our associations, for example, would have a complaint based upon, let's say, a request for a reasonable accommodation for an assistance animal. And with some of the language as currently written, it appears to put somewhat of an unfair burden on our associations as the respondents here to really show that the sole motivation for denying someone a reasonable accommodation is intentional. So I just would suggest taking that into consideration. One section that I did specifically want to address with the Council, which is section 12052, qualifying for an exemption. The language that I pointed out in my comments that I did want some clarification from the council on is the language that reads under section 12927C2A of the Act, an owner-occupied single-family home with a single roomer or boarder is exempt from discrimination liability. I think most of us who've been practicing a while and dealing with fair housing issues, frankly, thought that the term single family was a red flag for discrimination and that we would have to go through the whole Adamson analysis of what is a single family. We come up against these issues all the time when it comes to associations because most of our governing documents prohibit boarding houses, rooming houses, and shared housing type of arrangements. And we've removed from most of our governing documents the term single family just because it creates so much confusion in then having to go define what that is. So I would just suggest that if you're considering leaving in the term single family home, maybe we wanted to define what that is. I think we're using that mostly in our industry as a marketing term, if anything. And so I just encourage the council to take a look at that so we're not appearing to be contradictory in how we're approaching the idea of a single family home. With that, I will close and thank again the council for all its hard work, and I really appreciate all of your efforts and time that each of you put in, and I know I've spoken with many of you about common interest developments, and I appreciate your attention to the issues that are unique to common interest developments and associations, and if there's any questions that you have, I'm happy to answer them. Thank you.
Thank you very much. We always appreciate your comments and perspective on that in that context.
Thank you.
I'm now unmuting Whitney Prout.
Good morning, Director Kish and members of the council. Whitney Prout with the California Apartment Association. Happy to be back here, even if it's virtually. To comment to the council. We are finalizing our letter and we'll have that submitted here very shortly, which touches on a number of issues we've identified throughout the regulations. In my comments here this morning, I'm just going to focus on two issues. The first issue relates to two different sections of the regulations. The first is section 12041 subsection B. And my comment on that section actually relates to the initial statement of reasons, not the draft regulatory text. And then the other section is section 12042 subdivision E. And our concern with these is the same, so I'll address them together. And that is in the initial statement of reasons related to section 12041, the council notes that the motivating standard under FEHA that's applied to intentional discrimination cases is more protective than the disparate treatment standard used under FEHA, which has a different statutory text. It talks about discrimination because of inclusion in a protected class. And the council then takes that and makes the conclusion that case law under the FHA on this point is therefore inapplicable. And our reading of the case law is just that's not correct. The Ninth Circuit has actually interpreted that because of standard under the FHA to only require a showing that that the discriminatory intent was a motivating factor. And again, the Ninth Circuit has explicitly found that the standard of proof and analysis applied in an FHA disparate treatment case, that those are the same as those applied in the FEHA case. And so with that being the case, there's no reason to treat the two different statutes and their interpretation differently and to exclude the use of FHA case law in the FEHA context. And this issue appears in the draft regulatory text in section 12042 subdivision E, which in the burden shifting test requires a housing provider to produce evidence that their action was motivated solely by a legitimate non-discriminatory reason. And that standard is not what's been articulated in the case law. Under the FHA, it talks about the housing provider needing to produce evidence that their action was motivated by a legitimate non-discriminatory reason, not that it was solely motivated by a legitimate non-discriminatory reason. And that goes into the mixed motive issue that's identified in the initial statement of reasons. And again, because the FHA case law is equally applicable to FEHA cases in this context, as the Ninth Circuit's held, the regulation should reflect that, which is also required by the APA, which requires for consistency purposes that the regulations be consistent with applicable case law. Our second issue relates to section 12040, subdivision B as in boy, 3. And this is the section that deals with source of income. And we have a couple of issues with this section. I'm only going to speak to one of them here, which is that the definition of source of income in the draft regulations has been expanded to include payments by a guarantor as a source of income, as a payment made on behalf of a tenant. And this is extremely, extremely problematic for the rental housing industry, as it would require rental housing providers to allow prospective tenants who do not meet their screening criteria to essentially qualify by having a guarantor. And that is very, very problematic, particularly in cases where a guarantor may be in a completely different state or a completely different country. For example, parent of an international student. It may be completely impossible for a rental housing provider to protect their very legitimate business interest in ensuring the full and timely payment of rent if they have to accept an applicant who has potentially no income whatsoever, but says they have a guarantor who the rental housing provider may never be able to collect from. And this isn't just a matter of policy. There's really no basis in the statute for interpreting the source of income definition already provided in FEHA to include guarantors. The expansion of that definition under SB 222 and SB 329, the legislative history of those two bills show that they were very much focused on expanding the definition of source of income to include housing vouchers, but there's absolutely no indication that the legislature intended to open up that definition to guarantors. And if you look at California law that governs the nature of the guarantor relationship, it also makes clear that guarantors are not a source of income. They're not, paying wages to someone or anything like that. The case law and the statutes on point specify that a guarantor is essentially a surety or a creditor of their principal. And we've provided all of that case law and the statutory references in our letters, but this is something that is extremely important for our industry, and we would ask that the council take the amendments that we have offered in our comments. Thank you.
Thank you, Whitney. We look forward to reviewing your thorough and insightful comments as always as part of these housing processes.
Thank you.
I'm now unmuting Matt Warren.
This is Matthew Warren. Can you hear? Okay, great. This is Matt Warren. I'm a staff attorney with the Western Center on Law and Poverty. I'd like to first say hello and congrats Kara Grofier on her new position with DFEH. We at Western Center greatly appreciate the Council's continued work on these important regulations. Fair Employment and Housing Act regulations provide clarity for the department, housing providers, tenants, homeowners, real estate professionals, advocates, and courts, and promote consistency in interpretation of the rights and obligations conferred by the Act. Western Center, along with some partners, will submit some specific written comments today. We therefore suggest that Section 12042D should be amended to state that a combination of direct and circumstantial evidence may be used to prove discriminatory intent without the need to follow the burden of proof for indirect evidence set forth in the draft regulations. We will also submit some specific language for guidance related to the new definition of source of income, because we hope that the important new protections aren't circumvented by landlords simply failing to comply with housing choice voucher requirements. Thank you so much.
Thank you. We look forward to your written comments as well. Is there any other requests for comments or chat comments or email comments as part of the hearing?
Ms. Brenda Lebsack submitted a comment that we will email to all the council members after the 5 p.m. deadline. And Ms. Feng Huang sent in a brief note about her case. I could read it, but if the council prefers, we could respond about the specifics of her case since it doesn't relate to the rulemaking action.
Yeah, that makes sense, I think, given the fact that it does not appear to relate to the FEHA housing regulations. Well, seeing no one else wishing to provide testimony, we will close the hearing portion of our meeting and again remind people that you have until the end of the day today to get your written comments into the council to be included in our formal rulemaking process. With that, the hearing portion of the meeting is adjourned, and we will pick back up with our regular meeting topics. Our next item on our agenda is considering the modified text of the employment regulations regarding harassment prevention training, which is attachment E to the meeting materials. Councilmember Sandoval and I reviewed very closely all the public comments received, and we made a number of modifications as reflected in the revised text, and I'll just walk through a couple. I'll walk through them briefly, the modifications. On page 4 at A2A and B, we changed several more references from supervisor to employee that were missed in the first pass to account for the new statutory language. On page 7 at B1B, we added some clarification to the training year tracking method to avoid any misunderstandings and clarify that an employer may elect to spread its training over both of the 2 years within the training window, so long as the full training time is completed within the window. An employer does not have to select one of the 2 years in which they conduct the full training. On page 8 at subparagraph 6, we addressed the topic of duplicate training, and we revised the language to match the provisions of new legislation in AB 3369, which addressed this topic. Also on page 8, subparagraph 8, we clarified that employers have the flexibility to utilize either the same training materials for minors or different training materials that they feel are better tailored to successfully educating minors on these topics, provided, of course, that the materials meet the subject matter content and format requirements of the statute. We also clarified that parents may attend the training but are not required to, and this is consistent with new language in AB 3175. At the bottom of page 8 and top of page 9 in subparagraph 9, we fixed the first sentence to match the statutory language, and we also created some flexibility on the logistics of who provides the client-employer anti-harassment policies in a fashion that still ensures that the temporary services employer remains incentivized to assure compliance. Essentially, they can coordinate with the client employer to make the client employer provide their own harassment policies, but they remain on the hook to make sure that gets done. Councilmember Sandoval, anything to add before we turn it over to the other council members?
No, you covered everything. Yep.
Okay, great. Any other comments from council members?
I had a brief comment, and perhaps maybe I'll just throw it to the rest of my council members for their opinions on it. But on page 8, so this is B6 regarding duplicate training, and I understand we pulled the language from the statute, but I'm worried about ambiguity and confusion on the part of the employees and employers. The training, the duplicate training talks about training from a current, prior, alternate, joint employer, etc. But I know as a matter of practice, a lot of employers are receiving training perhaps from the Department of Fair Employment and Housing, chambers of commerce, HR groups, in furtherance or because their employer is asking them to do it. I'm wondering if there's confusion here because as read, you know, an employee or perhaps an employer may think that because the training wasn't provided in fact, exactly from the previous employer as opposed to from Department of Fair Employment and Housing in satisfaction of that employer's requirements, that it might create some confusion. So I just wanted to throw that idea out there and see if anyone else shared that concern.
I think the idea in the rest of the training provisions about the employer making available these training and then talking through all the different ways they can do that, including contractors or utilizing the department one. I think in that context, I'm not seeing any lack of clarification, but certainly I defer to others if they're seeing that as well.
I think it might not hurt to add just a phrase like, you know, prior employer in satisfaction of, or reference the other sources from which the training can legitimately be given wouldn't harm, I guess.
Well, I also think that that would be in line with some of the other provisions. Like, for instance, I think we're requiring the link to the Department of Fair Employment and Housing's training. So it seems like we are encouraging others to utilize these other sources. I think just some clarification that in this section itself, if they're just looking at this section, that those types of certified trainings in satisfaction of the other employer's requirements satisfy.
So let's see, where would we put that? We're in 9, right?
Can I propose just off the top of my head, a small change that might address it, but you guys tell me if it doesn't. So the current phrase is from a current, a prior, or an alternate, or a joint employer. Could we just replace from with during employment with a current, a prior, or an alternate, or a joint employer?
That would satisfy me, or in satisfaction of a current joint, current, prior, alternate, or joint employer's obligation. You know, something like that, I think would be fine.
I lean, I think, a little toward Director Kish's language only because there's a chance that an employer didn't have that obligation but still provided the training.
What about
that complies?
What if you just use and change the word from to for? I don't have the wording in front of me, but when you read it, it's training for that other employer.
Well, it's in the past that they received it.
No, they received it, but it was for the previous employer. I don't know. I was just looking for a simple way to just make without having to do much styling.
Well, I think Director Kish's was just adding a few words. That seems like an easy fix.
Yeah, I think that would satisfy me. I also think Dale's comments always are fantastic. I would be happy with either. I just want to make sure that an employer reading this will be clear that it doesn't have to be given by that prior employer, that it can be given in satisfaction of that employer's obligation by a qualified entity.
All right, well, let's firm up one or the other of those two alternative, just so we have it clear for a potential vote. What since Councilmember Ortiz, since you issue spotted this one, you want to propose specific language for it?
Yeah, to be honest, I'm happy with both the director's version, Dale's version, and my version. I just want something in there that allows them to understand that it doesn't have to be provided by that previous employer. I'm happy to take a crack at it and send it to you, but I'm also happy with Director Kish's version as well. If you want to repeat that, perhaps we can just make notation on it.
Yep.
Yeah, and I think the idea here is that if we make the change in real time and vote on it, then the council can vote this new version into rulemaking, into another 15-day comment period today. So I also don't have any attachment to one or the other, but what I had proposed is to modify the existing first sentence of subsection 6 duplicate training to read, an employee who has received training in compliance with this section within the prior 2 years during employment with a current, a prior, or an alternate or a joint employer, or who has received a valid work permit from the Labor Commissioner, blah, 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 blah.
So yeah, I think that's fine, and if it clears it up, I think it's worth it. I mean, it's worth noting that this language mirrors statutory language. So, you know, I think it's worth at least considering whether we invite further confusion by deviating from the language that's in a statute on this topic. But that said, I don't think the modification is going to like throw too much confusion. But I think that's the alternative consideration, is whether not mirroring statutory language creates confusion. I think we're all on the same point substantively what this means. And I'm open to either approach. I'm certainly fine making that change. I just want to flag that.
I mean, I'm fine with that change, but the phrase "in compliance" itself suggests that it's going to be done in a way that's in compliance, which means that it could be have been received by an entity separate and apart from the employer. So I think that the term "in compliance" already provides for the concern that Councilmember Ortiz has, but I'm not opposed to including the language proposed by Director Kish.
Yeah, and respectfully, I disagree with that, because it's in compliance from that employer. The implication, and maybe it's not very subtle, but the implication is that it had to be provided by that previous employer. You know, and I acknowledge that this is from the statutory language. I just think it would be clearer if it were, well, you know, that when they were employed with, as suggested by Director Kish.
All right. Well, why don't we incorporate that clarification in our next, you know, and we'll, as Director Kish mentioned, we'll do that during the vote so that it's already kind of in there in the next round that goes out for public comment. Any other council member comments? Hearing none, we will turn it over to any public comment on the revised text.
We have one speaker whose phone number is 607-090-595. There seems to be a number missing, but you are now unmuted.
I wonder if this is me. This isn't my phone number, but this is Kim Stone calling on behalf of M-Train in support of the proposed regulations, particularly in support of Item 8, Attachment E, the proposed regulations regarding harassment prevention training. M-Train supports the new Section B, proposed Section 7 regarding the duration of training, which explicitly allows training in segments as long as the total training adds up to the required amount. Shorter segments of training can be as effective as one longer block, or in some cases more effective for adult learners. Additionally, this proposed change will allow employers to train either all at once, or if it's a 2-hour training, 2 hours every other year, would allow them to do 1 hour every year, 30 minutes every 6 months, or any other combination as long as they accumulated the required total time. This flexibility will make it easier for employers to do the right thing and to comply with California law. We thank you for the proposed regulations and urge you to adopt them.
Thank you, and thanks for your insightful comments in the process.
We now have Janine Yancey, and you are now unmuted.
Yeah, hi, this is Janine Yancey, CEO of M-Train. So Kimberly Stone just kind of provided our comments, and just wanted to thank the council for your flexibility to allow multi-state California employers to do the right thing. That's all I have.
Thank you. Thank you. And both of you, next time you see her, do say hello to our beloved former colleague, Patty Perez, who we miss dearly, but is off doing bigger and better things with her book tour.
Will do. Thanks.
Any other public comments? Anything coming in a written form?
No emails.
Okay.
Chair, there was one comment from Janine Yancey in the chat box that I'll just read out into the record, which is in engagement on the prior question that the council was considering. Janine Yancey said, "How about sponsored by?"
So that would be another alternative phrasing to clarify. I think I lean still towards Director Kish's, although I appreciate the comment, just because sponsored by begs this question of, well, did the employer sponsor the DFEH training, or just, but then again, I think all of them are clear. So Councilmember Ortiz, do you have thoughts on kind of which of these approaches would clear up the concerns you spotted?
Well, I guess I'm worried about sponsored by only in the sense that, I mean, we hope that employees aren't flitting around from employment to employment, but it is possible that within 2 years, there's an individual who, has been into multiple locations, and I guess I'd be confused about sponsored by. I think I like Director Kish's comments or Dale's suggestion as well. I think it's modest, and I think we can do it pretty quickly just by changing the language to include, employed with as suggested.
Okay, great.
And Chair Mandelbaum, I should say that Miss Brenda Lebsek emailed a comment. It's not clear to me if she would like to speak. I don't know if Mr. Romero could unmute her mic and she could let us know.
She will need to raise her hand so I can identify her.
I see. Ms. Lebsek, if you could raise your hand, we could unmute your mic and then you could comment.
In the interim, I will read into the record a chat that came in from JT. Thank you for the clarifications. We appreciate where this is going. I agree with M-Train's comments. This is a big job. Thank you.
Might it be useful to repeat how to raise your hand for people who might not be exactly comfortable in Zoom yet?
Sure. On the menu bar at the bottom of attendee screens, there's a button that you can click that says raise hand. And all you need to do is click that and we will unmute you.
Brian, do you want, is there any substance in the email? Should we read that? Since we do not seem to be getting a raised hand.
It's a small paragraph I could read. It's not entirely responsive to the agenda item. Mr. Romero, should I read it out loud? Have you had an opportunity to look at it?
I have not.
For agenda number 8, you want to brainwash all employees that these unlimited genders are truth. Cut me off if you'd like. You also want to terrify us all of the consequences if we do not adhere to your most disgusting demands. The ACLU lawyer here today should quote their Safe School Coalition, which says instruction on gender in public schools is not subject to parent notice or opt-out laws. So parents, especially those who cannot afford private education for their children, have no choice but to subject their children to this indoctrination that assaults biological reality and their religious convictions and cultural mores. Agencies with gender clinics are now partnering with school districts while the California Teachers Association passed a policy in January of 2020 that hormone therapy for kids should not require parent permission for the sake of equity. And Newsom is ready to pass AB 2218, which will fund these gender clinic agencies. What a lucrative business you are all creating for yourselves, creating lifelong medical patients out of our children while sterilizing them. Isn't it interesting that CTA provided Fair Housing's definition of gender spectrum in their March 27 magazine, 4 months before the definition was even established? This appears to be collusion between CTA, Equality California, ACLU, Transgender Law Center, and Fair Housing. Please create a press release today so everyone in California can know that this new definition of gender identity you created 3 years ago for us all, and create equitable access of this information to our immigrant populations in the state. They deserve to know what is being taught to their children under the false facade of anti-bullying, safe and inclusive. Thank you for listening. Ms. Lebsack also submitted a public comment that will be distributed to the council members as part of the housing rulemaking action.
Okay, any other comments before we turn again? Again, our agenda item right now is on the harassment prevention training regulations. Any other comments on the harassment prevention training regulations depicted in attachment E to the materials?
No additional comments.
Okay, hearing none, I will move to adopt the modified text in attachment E with the one modification that we made in the meeting, which is at subsection 6. In the first sentence of subsection 6, we will change the language to read down to it that an employee who has received training in compliance with this section within the prior 2 years. Director Kish, sorry, what was your language again? Within the prior 2 years.
During employment with.
During employment with, instead of either from. So with that modification, incorporated, I would move to adopt the regulations and authorize the department to post for 15-day public comments. Any seconds?
Second.
All those in favor? We'll go with a roll call, so I'll turn it back to you, Brian.
Chair Mandelbaum?
Aye.
Councilmember Brodsky? Aye. Councilmember Iglesias?
Aye.
Councilmember Ortiz?
Aye.
Councilmember Sandoval?
Aye.
Councilmember Scher?
Aye.
All right, the motion passes, and the regulations will be noticed for additional public comment. We will now turn to our next order of business, which is a report from the Subcommittee on Government Code 11135. So I'll turn it over to Council Members Brodsky and Scher.
Dara, do you want to take the lead on this, or do you? We just have a brief report.
Go ahead, Dale, please.
Basically, our ISOR has the initial statement of reasons has been sent to the Office of Administrative Law, and it's pending there as we understand it. So we will get. Does somebody else have something to add to that that's more up to date?
Yes. The package has not yet been sent to the Office of Administrative Law. It's under review by other folks in government before we do so. As you guys recall, the council voted to introduce this updated regulatory package about Government Code 11135 into rulemaking, I believe in January or February of this year. And we've spent the intervening months working on the initial statement of reasons, and it's now being reviewed, and I expect will shortly be sent to the Office of Administrative Law to start a 45-day comment period. For folks who are in government or who are government contractors who are listening, this statute 11135, which dates back to 1977 or 78, prohibits all forms of discrimination in state-funded activities and programs. So every action that the state takes, the government takes, and all of the programs that it funds have anti-discrimination obligations. This is the law that states that, and these regulations are implementing it. So it's a major package. It, I think, draws attention to the importance of non-discrimination in everything the government touches. And so very shortly, we should be able to send that package to OAL to publish for a 45-day comment period, and we look forward to what I expect will be a robust comment on this package.
Great. Any public comment on the update from the subcommittee on 11135? Hearing none, we'll move along to the update from the Criminal History and Employment Hearing Subcommittee. I'll turn it over to my colleague on the subcommittee, Councilmember Sandoval.
Thank you, Chairman Mandelbaum. To have a brief update today, we're moving along nicely. We've been able to meet with different stakeholders and individuals and have identified some really great panelists from Legal Aid at Work, Root and Rebound, Inland Empire Fair Chance Coalition, the National Employment Law Project, Homeboy Industries, Microsoft, the ARC Fire Camp Pilot Program, and other experts and academics from UC Irvine and Penn State. We have been working, of course, with our community members and stakeholders from Legal Aid at Work for several months. We are envisioning, perhaps, as we look at the civil rights convening that took place earlier this week, about maybe expanding the day for this particular civil rights hearing to ensure that individuals have enough time to provide their significant feedback with regard to the Fair Chance Act and other issues surrounding communities with regard to this important topic. So we are still moving forward on November 17th. It will be virtual. And I'm not certain if Chairman Mandelbaum, you have anything else to add at this time?
No, I share your enthusiasm for where it's headed, and I think it's going to be a great day. Any comments from council members? Any public comment on this topic? All right, we will move right along to an update from the Criminal History and Work Opportunity Tax Credit Subcommittee. So I'll turn it over to council members Ortiz and Sandoval.
Certainly, and I guess I'll take it. It's going to be short and sweet. We're still working and absorbing. We expect that we should have a draft by the next meeting.
Great. Any council member comments? Public comment? Okay, our next order of business is a presentation by a number of guest speakers. We're very pleased to have you all today. Aditi Fruitwala from ACLU of Southern California, Elizabeth Kristen and Nora Cassidy from Legal Aid at Work, Ting Su from the Eagle Rock Brewery, and Ashley Louise and Claire Wasserman from Ladies Get Paid. We look forward to your remarks. I'll let you all introduce yourselves. Who would like to kick things off?
Hello, I can do that. Thank you all for allowing us to speak with you today. My name is Aditi Fruitwala. My pronouns are she, her, and I am a staff attorney at ACLU of Southern California. And I'm going to pass it off to Elizabeth.
Hi, good morning, everyone. I'm Elizabeth Kristen. I use she, her pronouns. I direct our gender equity and LGBTQ rights program at Legal Aid at Work. Thank you so much for having us, and I will pass on to my colleague, Nora Cassidy.
Hi, it's a pleasure to see you all. My name is Nora Cassidy. I also use she, her pronouns, and I'm a fellow and attorney at Legal Aid at Work in our Gender Equity and LGBTQ Rights program. Now I'll pass it to my fellow presenter, Ting.
Hi, my name is Ting Su. I am one of the co-founders at Eagle Rock Brewery. Pronouns are she, her, and excited to be here. So thanks for taking the time to hear us out. And I'll pass this on to Claire. Claire on yet?
She's here. I believe Adam's elevating her to a panelist.
Okay.
I am not seeing her on the list of attendees. Claire, if you can raise your hand, that will help me identify you. There we go. Thank you. And I'm promoting you to a panelist now.
Hi, everyone. Thanks so much for that. I'm Claire Wasserman. I am the founder of Ladies Get Paid, and my pronouns are she, her.
All right. Well, thank you, everyone, and thank you, Council, for allowing us to present to you today. I'm going to start sharing my screen because we have a PowerPoint prepared. Is everyone able to see that okay? Great. All right, excellent. So what we're here to talk to you about today is a really troubling trend that we're seeing with the Unruh Act. So as you all are well aware, the Unruh Act is for the purpose of, is our state civil rights law, and it was made for the purpose of preventing discrimination against marginalized populations. But instead, what we've been seeing in recent years is a rise in men's rights activists using the Unruh Act to sue organizations that empower women. And they filed several lawsuits in California claiming that any event they see that is meant to uplift and support women is a violation of the Unruh Act. For the Unruh Act, for organizations like ACLU of Southern California and for, oh, whoops. Sorry, I don't think I'm on full screen. Did that work? Great. So for organizations like ACLU of Southern California and Legal Aid at Work and other civil rights organizations, the Unruh Act is really our bread and butter. We are proud of this law that California has, and we've been able to use it to really fight discrimination and uplift marginalized populations like women and non-binary people. And because of that, we are really concerned with this trend that we're seeing of the Unruh Act being weaponized against the groups that it was designed to protect. So today we'd like to do essentially 4 things for you in this presentation. The first is we would like to share some stories from 2 businesses that have been directly impacted by this abuse of the Unruh Act, Ladies Get Paid and Eagle Rock Brewery. The second thing is we'd like to just give a really brief context discussion about why affirmative action type policies that uplift and empower women continue to be important even in 2020. Then we'd like to give just a really brief explanation of what the Unruh Act's case law says in this context. And then finally, we'd like to propose some regulations to this council that we think could address the situation. So I'm going to pass it off to Claire from Ladies Get Paid to talk about what she experienced for this abuse of the Unruh Act.
Thank you, Aditi, and thank you everybody for having us here. So yes, I'm going to tell you a little bit about our background, Ladies Get Paid, and what our experience was like being sued and what we hope happens. Okay, so I started Ladies Get Paid in 2016 after reading about, all these terrible statistics for women in the workplace. A few particular struck out to me. We've got the wage cap, of course. So that's, for Hispanic women, they are making close to 55 cents on the dollar. Less than 22% of women make it past middle management. Black women receive less than 1% of venture capital funding. I mean, the list goes on, you're probably well aware. And, you know, so the question became, what as an individual can you possibly do to combat something that is so systemic and so overwhelming? So the first thought was, let's just get a bunch of women together. So I hosted a town hall for 100 women to come. We talked about money, really, because of what money sort of represents, which is, you know, power and value. And the question for these women was, are you advocating for your value? And what became abundantly clear out of this town hall was that there were so many experiences that they had where they were discriminated against. I mean, some very obvious, others sort of insidious, a lot of harassment, and that there was a real need for us to come together and collectively sort of commiserate and then figure out, you know, again, as individuals, what can you do? And then also as together, could we become this body with power? And so, you know, I kept hosting events. They were specific to female identifying and non-binary people because the goal was to get these women to feel really comfortable, to be vulnerable and share these stories of harassment. You know, the thinking was, if they're talking about being marginalized by men, you know, how could we have men in the room? It just wouldn't facilitate the vulnerability that, you know, these women really needed to have with each other in order to be able to get to a place of progress for them. I just want to read a quote really quickly by a woman who's come to many of our events. She said that there's something that you get out of supporting other women and women encouraging other women to be successful that you don't get from co-ed spaces. She credits our group for helping her become really aware of her self-worth and to not settle for anything less than I deserved after facing several personal and professional obstacles in the past. There's also research out there that shows that women are way less likely to speak up if there are men in the room. So now we've been in business for about 4 years. We've grown to over 75,000 women from all 50 states and more than 120 countries. So many testimonials of women getting jobs, negotiating raises. We've had women run for office, including Alexandria Ocasio-Cortez. She is a Ladies Get Paid member. She declared her intention to run at one of our town halls. So, you know, it's working. But less than a year into running Ladies Get Paid, we were sued. We were sued for hosting 2 events. One was in San Diego and one was in Los Angeles. They were, you know, advertised as specific for women, and we explain why. The large issue here is that they didn't just sue Ladies Get Paid and me personally, they also sued 6 of our volunteers, the venues that hosted our events, the sponsors that donated to us, you know, so in total, this was 14 defendants, all of which I, you know, became responsible for. And it was particularly devastating to be sued under the Unruh Act because I'm a woman, I'm Jewish, I'm gay. So we've got 3 classes here of being marginalized. And I understand that the Unruh Act is meant to protect people like me and not to be weaponized against me. And another huge issue with this was that the group that sued us, and so this was a lawyer, and he sued over 300 times, each time citing the Unruh Act. There were 5 plaintiffs. All 5 have been the plaintiffs in many other lawsuits, also under the Unruh Act. And when we looked around at the various other groups, you know, it ranged the gamut from a firefighting camp in San Diego, helping encourage women or girls to become firefighters, nonprofits, the arts organization, any organization that's giving a scholarship for women, they were targeting. And as we were doing our research, you know, obviously the question for us was, okay, do we go to court? Because we feel like we have a case. It wasn't even an option to go to court because we couldn't find anybody who'd gone to court against these guys. I mean, it was just clear that they had a machine. The law very much seemed like it was on their side, even though, you know, philosophically, it didn't make any sense to us. And you know, it was obviously going to be very expensive. There's just me and a co-founder. We have no funding. You know, all of our savings has gone into Ladies Get Paid. And of course, it would be, you know, our legal fees. But that aside, I mean, how long would it take to be in court with these guys? And especially as we were Googling around, I mean, they won a $500,000 settlement from the Oakland A's for giving out hats to women on Mother's Day. So this was completely stacked against us. And so, you know, we had to settle. This lawsuit went on for over a year. There was a lot of harassment and intimidation, which, I won't go into. And, and the through line to this whole experience was this absolute shock that we could be sued. I mean, it really made no sense. And the only way that we were able to stay in business is we had a crowdfunding campaign, and over 2,000 people donated to us. We have a very large community who, is very upset, understandably. They've rallied behind us. And they also can't understand why an organization like ours would be sued. So, I think our goal out of all of this is to just make sure that there's some clarifying language that, that the law isn't used against the very people that the law was intended to protect, especially for groups that are hosting gatherings like we did that is explicitly for helping marginalized groups do better, so that we can shift, the balance of these statistics that are so far away from giving, women equality, especially in industries like tech, which is a huge one that we cater to, or the wage gap. So, I'm honored and thrilled to have this opportunity. I've been waiting for it for a long time, and I really hope that we can do the right thing here.
All right, thank you, Claire. Now I'm going to pass it to Ting Su, who is the owner of Eagle Rock Brewery, for her story.
Thank you. Yeah, so I guess I'll start out by, it's probably, people may wonder what does beer have to do with any of this. And I'll start out with just some statistics within our industry. The craft beer industry has been one of the fastest growing industries worldwide, really, in double-digit growths for over a decade. But it's also an industry that historically has lacked diversity. And so of this explosive growth, currently we had the most recent study done in 2019 was the first study done by the Brewers Association to actually find out a little bit more demographic information. Background on that is we've got 7.5% of brewers are women. Only 4% of brewery ownership are women, and 88% of brewery ownership are white. And so it's definitely something that the industry as a whole has been trying to address. Our brewery, Eagle Rock Brewery, is based in Los Angeles. We opened in 2009 as the first brewery in the city limits of LA. So we're on the front end of that explosive growth within the industry. And during that point in time, since we were one of the founding breweries, we started a Brewers Guild, and we took it as an opportunity to start a culture of diversity and inclusivity. We really focused on trying to engage as many people as we could, color, gender, whatever it may be, it's just like we just wanted to try to have a very diverse culture that was reflective of the culture that we have in Los Angeles as a whole. And so back in those days where I was still at the brewery every single day, still behind the bar most evenings, after we would finish our brews, I was noticing that there was a huge disparity in knowledge and comfort level of women coming into the tap room. So they would come in out of curiosity, or they would come in with a significant other, hetero male or cisgendered male, and almost invariably their opinions or thoughts would get discounted. And so I started a women's beer forum back in 2011 to create more opportunities for women to learn about beer. It's a monthly forum, educational forum, discussing classic beer styles, discussing the nuances of the brewing process. And during that course in time, over the past several years, have created quite a following for it. And then additionally, many of the attendees have actually moved on to get jobs within the beer industry. Additionally, we've even had members that have moved on to create their own breweries and start their own breweries within the county of Los Angeles. So it's definitely something that's gotten a following. We work a lot in Northern California as well as Southern California to create these educational events and opportunities for people who identify as women. And so in 2017, we actually got an email from a men's rights activist through the National Coalition of Men, who essentially was telling us that we were in violation of the Unruh Act, and that he named a number and what we should be paying him out to make him go away, and threatened essentially to file claims through the ABC. And ultimately, since the ABC doesn't actually oversee any of that, he ended up filing a claim through DFEH. So, and this is back in 2017. Our challenges were a little bit different in the sense that we did not get filed with a lawsuit. What we did was we got a claim filed through the DFEH against us, and the representative from the DFEH did not give much clarification on the process. And so our issue became that we weren't entirely sure how we were supposed to handle this, because it wasn't just a clear-cut lawsuit. It was going through a government agency. We worked closely with our attorneys. The entire process did take close to a year before there was any kind of closure to it. During that course of a year, we had spent over $14,000 in legal fees for our attorneys to draft a response to DFEH. And after all of that, the response from DFEH was still very unclear, even to our attorneys, that we should essentially, this is what the claim is filed for, this is how much money they're asking for, and how much are your clients willing to pay him, was essentially the presentation that they got from DFEH, or our attorneys rather got from DFEH, which was quite shocking for us as business owners, particularly since we were doing something that is very highly regarded within our industry for improving diversity. And so our biggest issue with this has been the lack of clarity in process and how things are interpreted by the DFEH with regards to the Unruh Act. But we've since then, had to settle out, because we were essentially told that if we weren't willing to pay a settlement, then it would be escalated to legal action. And so we did settle, but I've been working a lot and speaking with a lot of legislators on exactly how we can at least try to mitigate the predatory use of the Unruh Act against small businesses, particularly businesses who are in industries that lack diversity and are really working towards improving on that. So I appreciate that you guys taking the time to hear us out and the opportunity to present our case.
Thank you.
Great. Thank you so much, Ting. I'm going to pass it off to Nora Cassidy, who's going to give us a little information about why these types of policies are really important to empower women and increase diversity in these industries.
Thank you, DT. So I just wanted to kind of pull out for a second here and think about the fact that in Congress, where just 24% of the House is female and just 26% of the Senate, there is a women's caucus. And women in Congress created this bipartisan forum to discuss major policy issues of our day with a focus on how these issues impact women and families. They work together to raise awareness of women's issues, and then they take action. And their priority is to strengthen relationships in the caucus and with women in governments around the world. And organizations like Congress have found that when women feel comfortable in their own space, then they are able to talk more freely and openly. They are able to, this then leads to building power and rectifying gender inequality. I mean, it's true for trauma victims who are seeking female-only shelter, lawyers who face stereotyping and unconscious bias, girls who want to break into engineering or computer science but don't know any female scientists, and business people who have realized that they're being paid less than their male counterparts. Through these conversations, women build solidarity as they realize that their experiences are shared experiences, and then they begin to work to correct the inequities. And it's necessary because women remain significantly underrepresented, particularly in traditionally male spaces like tech, advertising, major league sports, politics, and finance. In 2015, only 5% of the companies in the S&P's 500 index had female chief executive officers, and fewer than 3% of board directors at Fortune 500 companies are Asian, Black, or Latina women. If you could go to the next slide, please. Just as the US Congress has recognized that women will not achieve equality anytime soon without concerted action, the California legislature has also recognized that to create equity, the law must acknowledge that the present day underrepresentation of women and people of color is caused by centuries of discrimination, and it won't be remedied without taking affirmative action. So on June 24th of 2020, the California legislature voted to create a November ballot measure to permit college admissions and government contracting decisions with a focus on race and gender diversity. And this historic shift in policy is something we want to focus on because it reflects a new, wider cultural understanding and acceptance that we have a collective responsibility to affirmatively create and to foster opportunities for marginalized people and for women, just as Claire Wasserman and Ting Su have been trying to do. And now I'll pass it back to Aditi Fruitwala. Thank you very much.
Thank you, Nora. So Legal Aid at Work and ACLU of Southern California have received dozens of intakes like Claire's and like Ting's, talking about how people are being sued for having events that try to empower women. And so in trying to figure out how to address this, we all sort of dove into the case law of the Unruh Act and realized that, of course, the Unruh Act doesn't prohibit all discrimination. It prohibits discrimination that is arbitrary, that's invidious, and unreasonable. And the case law has found that practices that further a compelling societal interest are not arbitrary, not unreasonable, and not invidious. So the memo that we submitted with this presentation to the council really goes into more detail about how the case law in this field has developed. I just want to kind of highlight some top level instances that have found to be a violation of the Unruh Act and found to not be a violation of the Unruh Act, just to sort of give some examples. So one is a retirement community prohibited children from living there, and they were sued for age discrimination. And the court found that retirement communities are designed for particular needs of the elderly, and those needs further a compelling societal interest, so there's no violation. Another is a movie theater offered price discounts to children. They were sued for age discrimination, and the court found children can't work because of child labor laws, so children don't have money, so offering discounts furthers a societal interest, and there's no Unruh Act violation. So I first gave two about age discrimination because the majority of cases in this field are on age discrimination, but I want to cover a little bit about what cases have said about gender discrimination. So a bar had a ladies' night promotion that offered discounts to women, and men sued saying that this was sex discrimination. And the court agreed. The court said that a promotion that allows women to drink cheaply doesn't further a compelling societal interest. And so that did violate the Unruh Act. In another case, a nightclub denied entrance to a transgender woman because she was wearing a skirt. And she sued for sex discrimination, and the court agreed and said that yes, dress codes that are based on irrational stereotypes about what people who are assigned female at birth should wear and what people who are assigned male at birth should wear is a violation of the Unruh Act. So those are two examples of gender cases that there were violations because the type of gender discrimination that was occurring did not further compelling societal interest. Now I'm going to cover two that did further a compelling societal interest. A baseball team gave away a free tote bag to all women on Mother's Day. Men sued, alleging sex discrimination, and the court found that the promotion was not sex discrimination under the Unruh Act because it sought to honor mothers as a group, and honoring mothers furthers a compelling societal interest. Another example of furthering a compelling societal interest is a promotion that a golf course gave. A golf course provided discounts to women during Breast Cancer Awareness Month. Men sued, alleging sex discrimination, and the court found that there was no violation of the Unruh Act because the promotion encouraged women's participation in golf and it raised awareness of breast cancer, both of which further compelling societal interest. So I just want to give these examples of just a few of the ways that the case law has developed in this field. And when we looked into the research, we found that the Unruh Act itself is not actually the issue, is not actually the problem, and even judicial interpretation of the Unruh Act is not a concern. Where the problem comes is that most people and most people's lawyers, like Ladies Get Paid's attorneys and Eagle Rock Brewery's attorneys, don't know that this exception exists because there's really no guidance and there's no clear instructions on how to do the analysis of whether something is a compelling societal interest or not. So that brings us to the last point of this presentation, which are the regulations that we are proposing to provide more guidance to businesses like the ones that we've discussed today. And I'm going to pass it off to Elizabeth.
Thanks, Aditi, and thank you to Claire and Ting for sharing your stories, and thank you to Nora. We were hearing a lot about the problems and the issues that these small businesses were facing with respect to the Unruh Act being abused and, as you've heard, weaponized. And we wanted to come up with something that could really help with the clarity if a business owner does receive this kind of threat or demand from a hate group, that they would have some assurances from the council about what is the interpretation of the law, the regulations that could basically incorporate, solidify, and put in one place what the case law already says, which is that not all types of distinctions between people are prohibited by the Unruh Act in public accommodations. And that it's really designed to prohibit arbitrary discrimination that doesn't further a compelling societal interest. And from our perspective, businesses like Ting's and Ladies Get Paid really are furthering a compelling societal interest. And so what we did was try to synthesize the case law into proposed regulation. We understand, especially from being here today, that regulatory rulemaking is a long process for the council. And we're really hoping to open a conversation with you today about what this might look like, and of course are open to your thoughts and suggestions about what we might do to strengthen this if you're willing to take up this idea of a proposed regulation. But what we wanted to propose was that a business establishment could show that there was no violation of the Unruh Act if there's a compelling societal interest for the policy or practice, and that to show that, they would demonstrate by preponderance of the evidence these elements: that the policy or practice furthers a compelling societal interest, that it effectively carries out the identified purpose, and that there's no feasible alternative that the business establishment could use to accomplish this identified compelling societal interest. And we also put forward a number of hypotheticals. These are all in our presentation and they're all in our paper. And so I want to just run through them very briefly because I know we're short on time, but I did want to kind of highlight how we think the answer would come out under our proposed regulation. So next slide, please. Aditi already flagged this issue of the ladies' night discounts. Those already have been found to be unlawful by the California courts. And we believed it would fail under element 1 of the regulation because wanting more women to be present at the bar would not be found to be a compelling societal interest. Hypothetical 2 on the next slide is about a sporting goods store holding a girl at play event to really bring girls in, maybe give away a basketball to the winner. This is focused on making sure that girls have participation in sports. And so next slide, please, under the application here, we assert that the business would establish that first element because making sure that underrepresented girls get to participate in basketball is a compelling societal interest. Teaching girls about basketball and offering an incentive is an effective way of making sure that this would achieve the purpose. And there's not a feasible alternative way to make sure to achieve this purpose. So we assert that this would pass the test of the regulation. Moving on to hypothetical 3. This is about a mammogram that's given away to the first 100 women who attend to increase breast cancer awareness. Again, we believe this would pass under the proposed regulation because this is a compelling societal interest, and mammogram screening would be directly tied to breast cancer awareness, and that there wouldn't really be a better alternative. And by contrast, perhaps something like giving out pink ribbons only to women might not pass this test because you could increase breast cancer awareness by having everyone wear pink ribbons. Hypothetical 4 is really based on Ladies Get Paid, a nonprofit dedicated to fighting discrimination against women and girls, decides to combat that pay gap by holding an empowerment event to teach women and girls how to negotiate for higher salaries. We believe this would also pass the proposed regulation because it would be eliminating the pay gap as a compelling societal interest. Teaching women salary negotiation in a safe space where they're supported by other women and girls is the type of practice that would effectively carry out the purpose, and there's not a feasible. Moving on to a mentorship hypothetical, this is the issue of these organizations that are nonprofits that try to encourage girls, for example, to get involved with STEM, organizing a mentorship program, and we believe this also would pass this regulation because mentorship and making sure to eliminate the gender gap in STEM would be a compelling societal interest. That this would be a method that would achieve that stated purpose, and there's not a practice that would better accomplish it. And finally, hypothetical 6 is about a golf course that is promoting a women golfing event, again, recognizing both that this is an area where women are underrepresented and also that golfing can be a path towards business success for women. Applying on the next slide, the regulation to our proposed hypothetical is that the golf course would establish element 1 because of this well-established gender gap, and that having women learn about golfing and the networking that it can provide would be a compelling societal interest. Teaching women golf would be directly related to that first purpose, and there's not really a feasible alternative there. And so we assert that this hypothetical 6 would also pass the test of the proposed regulation. So these are our thoughts on the way to solve the problem. We wanted to come to the council to bring up this really important critical issue. We obviously fully support the purposes of the UNRU Act and believe that it needs to be robust and strong, but we also need to see that it isn't being weaponized and used by a hate group in order to target marginalized communities who then are left with little alternative but to settle and pay thousands of dollars to repeat lawsuit bringers under the UNRU Act. So thank you for your time and attention, and we're happy to answer any questions. We really appreciate all the time you've given us today. Thank you.
Well, thank you all for your presentation and for the materials. For those who haven't seen them, attachment G to the materials available to everyone in the public includes both a PowerPoint and also a memo outlining some of the case law and elaborating on this issue so everyone can follow along. I know we have talked for a long time about forming a subcommittee related to UNRU to examine the regulations more generally, and perhaps we will be revisiting that later in our agenda. Did anyone on the council have any comments or questions before we move to the next agenda item?
I have some questions, but I want to defer first to any other council members who want to ask some questions.
This is Dara. Thank you so much for that presentation. It was very helpful. And I'm so sorry that you had to face some of those issues. I am very much concerned about the problem, and I think the council will seriously be looking at how we can regulate it. But the concern I have is that what a societal interest is and how this gets interpreted depends a lot on who's doing the interpretation. And that might be interpreted 100% differently under the California Supreme Court than it might, for example, under a Supreme Court as now or potentially constituted. And it could be widely, I guess I'm worried about misuse of this language as well as the underlying language by people who have different visions about what societal goals are and what the best alternatives are for a variety of things. And I don't know if you have given any thought to that in terms of crafting the language. I can see you've given a lot of thought to the language, and I'm very appreciative of that, and I'm sure the council will be talking further about it, but that's just a concern I have. Kevin, I'm not sure I need a response from the speakers right now, but Kevin, you may have something.
Councilmember Sandoval, I think you had your hand raised as well.
Yeah, along those lines, what Councilmember just mentioned, it would be helpful also to provide some language that's been used by the courts as the basis upon which they found certain actions to be lawful. Any principles. I know many of these decisions are fact-specific, but it would be good to see if there's any language, maybe even dicta, that can provide some cornerstones or key elements in considering whether or not a particular action or conduct by an employer or some other entity is not in violation. That would be helpful.
You know, I would just jump on and echo. I agree with both comments from my fellow council members. I think it is something that we should take a look at, although I would want to deep dive into the case law. I'm worried about the standards, and I really would want to look at it and make sure that we're not opening the door or inviting misuse of an application of this exception in a way that's not intended. So I'd want to make sure that the language is on point when it comes to the case law and specific.
I also would thank you very much for the presentation. It's very thoughtful and very detailed, and I appreciate that. I share the concern of the council members for the issue, and I think maybe, you know, the council should take it up in some fashion. I guess the only comment I would make is there is a real problem in law about dealing with the effects and legacy of past structural discrimination, and the formalism of typical anti-discrimination law doesn't help deal with that. And I appreciate that your proposed suggested language tries to do that by bringing in what is a compelling societal interest. But I do agree that there's some difficulty there too. So, you know, the formalism doesn't help, but when we bring in kind of more substantive analysis of that a court would make, that we as my other council members suggest, we need to really give guidance and make it, you know, and build on what the courts have done so far. So thank you very much.
And I would add to that, I agree. I mean, I think we need to take a hard look, and I appreciate that portion of the presentation at kind of where the case law lands, because we obviously know that notwithstanding the sort of historical motivations for statutes, the language is what it is, and reverse discrimination is obviously illegal in certain contexts, and I know you guys aren't arguing otherwise. In terms of Prop 16, I think it will be illuminating on that narrow front at least to see how the vote turns out, because obviously the legislative action was just to put it on the ballot, and we'll have a ballot, and there isn't, you know, currently a proposition on the books. But I really appreciate the presentation, and the memo, I think, also gives us all a good starting out point to review the case law and look at kind of both the standard and how it plays out in a variety of factual circumstances.
And just, I'm the only one who hasn't chimed in, but I want to add my deep gratitude to you for bringing this up. I recall back maybe 40 years ago when the Bohemian Club case was litigated, and you know, that was the other side of the coin, and so it is a challenge, and I think we're all going to have to really think very, as all my colleagues have said here, really hard on how we deal with this. And I do think it's within the council's purview and also our obligation to join you in looking at this and trying to figure it out. So thank you so much.
It seems like there's a common theme of underrepresentation being the compelling societal interest, and that's the theme of all your hypotheticals. So I appreciate all of you for providing this information to the council.
So I want to weigh in a little bit, and first I want to say to join the council members in thanking you all for this presentation, because I think a lot of these issues have been swirling around for a long time. And what you did is really two things. One, in the personal narratives, describe why the issues are important, and the actual real world effects of the law and potential misuse of the law. The other thing that you've done is kind of provide a framework for thinking about how the law, or maybe your framework isn't so much for thinking about how the law should be interpreted so much as how this council should educate people about how the law is interpreted. And so I'm really grateful for that too. I do think that as we move from an approach of formal equality to an approach that might be described as substantive equality, like what is the actual lived experience of people on the ground, that we do run risks of creating unintended consequences, especially because, I don't know, I think the question of who decides who is marginalized is fraught. I think when we're relying on ideas of past exclusion, there is not a single area of human activity from which women have not been systematically excluded, not just women, but other groups as well. So I do think that these are the issues that the courts grapple with. So let me make one comment about the case law and then ask a couple of specific questions to help guide our discussions going forward if the council decides to form a subcommittee to approach this. The one thing that I will say about the case law is that with respect to the courts and the judiciary, I don't think it's particularly coherent in the context of the Unruh Act. And so I would look at something like the golf course promotion, which was in fact a commercial promotion providing discounts to women. And when I look at that decision, and not coincidentally, the plaintiff in that case is the same plaintiff as in the administrative complaint against Eagle Rock Brewery. So we know that there's, a handful of people who are bringing these claims. What it seems to me is that, again, with respect to the court is impatient with this claim. And so in ruling that there was a societal interest in providing this discount to women, I think that decision says more about the esteem in which the court held the plaintiff than about where the law should go. That decision is unpublished. You've provided the citation in your memo. I'm skeptical of relying on that decision as precedent for council rulemaking, but I just want to flag that for you all. So here are a couple of specific questions, and let me preface this by saying that this is not oral argument. So for Ms. Fruitwala and Ms. Kristen, it's perfectly fine to say, I don't know, or mind your own business, and we'll figure it out as we go forward. And certainly if the council decides to form a subcommittee and move things into rulemaking, there will be ample opportunity to provide public comment. So 3 broad questions, and again, if you don't have an answer today, no worries, but I'm interested to hear if you do. 1, how do you view this proposed standard, the proposed regulatory standard involving a compelling societal interest to interact with an existing defense to an Unruh Act claim, which is a legitimate business reason, right? And so my understanding of the case law is that businesses can defend against a claim of arbitrary discrimination under the Unruh Act by saying that they have a legitimate business reason for doing so, but not when the challenged discrimination involves an enumerated protected class. So I think what you're suggesting is that there be 2 potential defenses to an Unruh claim. 1, a legitimate business reason when the discrimination or the alleged arbitrary discrimination doesn't involve an enumerated class, and perhaps a second and more stringent type of standard to assert a defense when there is discrimination based on a protected class. Does that sound right to you? Is that what you're suggesting?
Elizabeth, I can start since we're not in the same room and can't actually look to each other. I can start, and then I would love for you to jump in. So actually, just generally, I want to thank you all for your really thoughtful and considered responses to our presentation. And exactly what you've stated today is what we've been grappling with for the last 2 years. This is not an easy area of the law. The problem is clear, and the way to address it is a little tricky. And so in even proposing these regulations, we did a number of things. We looked really closely at the case law, which is where that compelling societal interest standard comes from. But Kevin, as you said, it's pretty uneven in the way that courts have decided how they come down on that and when they apply it, which is exactly why we're requesting guidance from this council so that businesses like Ladies Get Paid and Eagle Rock Brewery can, just be clear about what their obligations are and whether they're allowed to have events that empower women. I mean, we just need sort of more clear regulations so that people can proceed forward. And as far as, and also just as an explanation of where we got sort of the language that we're proposing. So it's from case law, and then also from looking at the way that other states and localities have addressed this issue. We are, we're not the only one that's kind of considering this. And so there are many other states that have kind of implemented what they either call a compelling societal interest exception or a public policy exception. And so to Gabriel, to a question that you asked a little while ago about, are there patterns that we're seeing in the way, what would be considered a compelling societal interest? One thing that's arisen, which is contained in the memo that we submitted, is if there is a clear public policy going towards protecting a certain type of practice, which is why age discrimination is actually what's kind of most clear in California law, because there are so many laws have been passed to either protect minors or protect elderly people. And so it's clear that there are ways to do that further California policy. And we believe that that's also true for gender, which is why we gave the example of Prop 16 and various other things that California has recently passed to sort of, to decrease the disparities in gender. Kevin, to your specific question about how the legitimate business interest would come into play, the memo contains, a little section talking about the legitimate business interest, but I think it doesn't specify exactly what you just said, but I think that that's right, that we would just need to kind of have a clear enumeration of if it was a protected category, there's a different type of analysis than if it was just discrimination at large without a category that has been enumerated. But that said, I think that the regulations we're proposing are really a starting point. We wanted to flag the issue for you and, kind of invite this conversation that we would be happy to present more research on, more analysis about anything that we can do to be helpful, because we recognize that this is the problem is clear, and I think the solution is a little tricky, but it's really worth delving into.
Good question.
Sorry, go ahead.
No, go for it, Kevin.
Well, I was just going to say I appreciate that, and my questions are also intended to be preliminary to help us think about what the subcommittee, if one is formed, would dive into. I have two others. Chaya, did you want to jump in on this point?
Well, I don't know exactly if it's on this point, but just in terms of the factual and case-specific murkiness of this, that's the tension in regulations in general, right? The brighter the line, the more nonsensical it is applied to the myriad of factual, complexities in life, and the more flexible and broad brush it is, the less guidance it gives. But I think another area that is begs a lot of clarity, either regulatory or just in the case law, is well, what slice, when we say kind of marginalized communities, when you guys use that term, I presume you mean mostly in the broadest of sense or historically, but there's also the question of as applied to what the context of the business establishment is doing, right? So they may be hosting an event, for example, on how to get a master's degree, and as you point out in the memo, at this point, women outnumber men in master's programs. So in that context, they're not marginalized or underrepresented. And would the regulation allow men to have exclude women in the context of, how to obtain a master's degree program? So I think something that begs a lot of thought, and I think we do need to honor the fact that the protected categories do not bend one direction, that gender works in both directions in discrimination laws, is, well, when we say marginalized or a societal interest, we have to be focused on the context in which the program, the exclusionary program is applied, and that may not match historically marginalized communities or genders in other contexts. So again, just the start of the thought, but we need to kind of think through, and whether that's a level of specificity that can be worked into regs, or how we provide clarity on that in the myriad of complex contexts in which this could be play out.
One other question, when we're talking about compelling societal interest, and I agree, this is the kind of black box, right, that we rely on courts to determine. When we're talking about kind of administrative enforcement of the Unruh Act, which obviously is the perspective that I'm coming from, thinking about our investigators and the experiences of folks who go through our process, are you suggesting that we look to sources including equal protection law, constitutional case law to kind of frame the compelling societal interest? I'm just curious about your thoughts about the intersection of this proposal with equal protection constitutional doctrine.
You know, I don't think that we've made a specific proposal in that direction. Elizabeth and Nora, I'm not sure if you have thoughts on this.
Not that specific issue, but I did want to just comment that I agree with Aditi that this is not the easiest of problems to solve, but I do think that finding some principled through lines to this can look to constitutional law, can look to the existing case law, and you know, and I think must look to this idea of the compelling societal interest that the Unruh Act was designed to address and to move away from this idea of formal equality. We decided not to include this concept of marginalized groups or historic underrepresentation, but we think that it could be part of the way that this was described. But this may be one of the situations where the regulations alone will not give enough guidance, and that we will also need something like FAQs and other kinds of guidance from the council to make sure that people understand. I mean, our main purpose here is to make sure that businesses know on the front end, what are they getting into here? You know, can these kinds of events pass through an analysis under the Unruh Act because it's not the formal equality law that it is sometimes presented to be? Or should they just not? And if the answer is should not, then I think businesses need to know that as well. And I think that it makes it incumbent upon the department and the council to provide education to businesses that the enforcement arm of the FEHC is going to say absolutely no women-only events, absolutely no, you know, African-American empowerment scholarship events. But whatever it is, I think it's just only fair to let businesses know that, because I think part of what's been hard here for the businesses has been the absolute lack of certainty, and then putting them in this difficult position of feeling that they were right, but they have to pay off because they can't withstand litigation. So I don't know that that totally answered your questions, but I think these are great, thoughtful questions, and we welcome opportunities to talk about them more.
And I couldn't agree more that, you know, the more clear guidance that folks can get, the better, just in general. Final and probably most specific question, do you have a burden shifting proposal for the framework that you've described?
We didn't at this point suggest burden shifting, mostly because we wanted to provide businesses with clearer guidance on the front end. And we were thinking that once you get into burden shifting, it starts to create more uncertainty for the business. But I think a burden shifting approach could work here. It could be something that the council could consider. I could imagine burden shifting being an effective method. It certainly works in a lot of other areas of discrimination.
And I wanted to, my colleague Adam Romero has thought pretty deeply about these issues. Adam, I don't know if you have other comments or questions that you'd like to pose.
Thanks, Kevin, and thank you everyone for the excellent discussion and presentation. These are important questions that we're asking and beginning to explore. I wanted to see Aditi and Elizabeth and your colleagues, if you've have guidance for us yet on the question of a fact pattern where a business is seeking to empower one minority group to the exclusion of another minority group. So in other words, there may be compelling societal interests sort of on both sides of the equation, and how the law could respond to that.
So I mean, this is sort of the classic response, but I think it is really dependent on the facts. And so I can imagine something that would be really particular to a group that could further California's public policy and compelling societal interest. And one thing that I can maybe imagine is a group for Black people dealing with the trauma of police shootings. Right, that was for the exclusion, and I could imagine that when you put that into our three-prong approach, that could come out as a permissible type of practice under the Unruh Act. But I think it's a little hard to do in the abstract.
This has been a very thought-provoking discussion. I do also want to remind those in the audience that since there's no action item and this was a presentation, there isn't a public comment associated with this specific agenda item, but there is a further public comment agenda item coming shortly, and that will be on a topic of whatever participants choosing. So people will have an opportunity to comment on this or any other thing they'd like to share with the council shortly. So hearing no further council members chime in, thanks again for all of your presentations and for this thought-provoking memo that you included, and I think it's the beginning of a discussion for sure.
Thank you.
Thank you so much.
Thank you.
Thank you.
Thank you, yeah.
Okay, we're going to move along to our next agenda item, which is to consider the changes without regulatory effect, which are contained in attachment G. And these are the ones incorporating the new legislation by Governor Newsom that Director Kish mentioned. And I'll turn it over to my colleague on the subcommittee, Councilmember Brodsky.
Yes, Chairperson Mandelbaum and I have revised the regulations, and that's the draft that you have there to implement SB 1383. And as Director Kish mentioned, what it does basically is it sets a new threshold for what employers who are subject to the Family Rights Act, which is still called CFRA now. But it does not distinguish between 50 and 20. It's now 5 is the minimum number. The new law, and so it basically repeals the new Parent Leave Act, which was bringing the number down to 20. It repeals the existing CFRA that was referencing 50, and we now have a new section 12945.2. And the current the new law will kick in January 1st, 2021. So what we did was we just took the new law and incorporated all of the changes in the new law into the existing regulations. We did not make any substantive changes from what there was, other than just taking the new terms. In addition to the terms that Director Kish mentioned, the law is significant. Another thing that, besides reducing the number to 5 employees and expanding the family members who are covered, SB 1383 also deletes the provision that had been there that permitted an employer to deny reinstatement to an employee who was among the highest paid 10%. That's gone. Within 75 miles. That whole 75 miles part is gone. The number is not referencing, is not in relation to how far away you were from a work site. That part has been deleted. It also deletes the provision that had permitted an employer to limit parents who worked for the same employer who had a new child to have to split that 12 weeks. Now each individual is entitled to the 12-week leave. So that's new. And then the new law, the new SB 1383 also included new language about the hours and how one is an eligible employee if you work for an airline as a on the flight deck or as a cabin crew member. And then finally, it clarifies that members of the armed forces who have what's called a qualifying exigency are now entitled to 12 weeks leave. So the law did a lot. The new law does a lot in expanding rights, which is great. And what we did was just incorporate, as I said, that into the existing regulations, which is why it's really regulations without any substantive change. So that's what you have there before you, and we are asking for, I guess we need to like to make a motion that we move this into rulemaking.
We'll need to get through council member discussion and public comment on it.
Sorry.
But that's right. Then we will make a motion, and as Councilmember Brodsky mentioned, because it's designed to conform the regulations to the new statutory changes, it qualifies as a change without regulatory effect, which allows us to fast track updating the rulemaking to conform with the statute. And as Councilmember Brodsky mentioned, and Director Kish as well, this is significant. All told, it will bring these crucial protections to an additional 6 million Californians. Are there any comments from those on the council regarding the draft?
I support it, and I appreciate the lightning speed with which you acted here. So good work.
All credit to Councilmember Brodsky on that one. I think within 24 hours, I don't know, she was highly caffeinated. She turned around the draft.
Well, I think we're all motivated to make sure that's so confusing, because with the old CIFRA and the new NPLA, and now with this new statute, I think it's really important to be able to provide guidance that is contemporaneous with as much as we can with the new statute. So that's what I think was driving me, and everybody in the team. It's a team effort.
Any other council member comment?
This is Dara. I think it's great, and I'm impressed with the speed. Can you tell me again what the statute was? The bill?
SB 1383, and the author was Senator Jackson.
Thank you.
And it was approved by the governor just a week or so ago, so on September 17th.
That's amazingly fast. Thank you.
I should say signed by the governor a week ago.
Any public comment on the draft?
No comment on the draft.
Okay, so then I think Dale has, Councilmember Brodsky has already started this motion, but it will be to adopt the text and authorize the department to submit to OAL for approval as changes without regulatory effect. Brian, am I missing any magic words?
And give department staff authority to make any changes requested by OAL.
That's correct, in order to approve the draft.
Second? Oh, I made the motion.
All right.
Yes, I made
You made the motion. I'll second it. We'll do a roll call.
Chair Mandelbaum.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Ortiz.
Aye.
Councilmember Sandoval.
You're on mute.
Aye.
Councilmember Asher.
Aye.
All right, the motion passes unanimously. So our final order of business before our final public comment is the consideration of subcommittee assignments, and we've already there's been some foreshadowing already on potential subcommittees, including UNRU or perhaps the hate violence post-hearing examination. Does anyone want to lead the discussion on subcommittees they think should be formed or ones they'd like to volunteer for?
I have one. I would like, in addition to the other two, I would like to propose a subcommittee to study and consider the possibility of amending our disability regulations to include disability on the basis of association with someone with a disability, which is so if anybody remembers the Castro Ramirez case, the Court of Appeal case, and the Supreme Court, the dicta in there, and a federal district court case from Southern California would support including this. And I think it's very important that we do this, especially now in the time of COVID, and with also the backdrop of having CFRA being amended to look at what other protections are provided under FEHA, especially given the definition of disability that's in FEHA. So I would like to propose that subcommittee to look into that, and I would volunteer to be on the subcommittee.
I'm not familiar. My understanding is that FEHA already includes as a definition that a person who's associated with somebody with a disability is also covered. I'm not sure if that's correct. So are you suggesting
whether you can adapt, the employee then can ask for reasonable accommodation? The employee can ask for reasonable accommodation, say, for example, to take a leave because they have to administer dialysis to someone, a family member, a friend, or someone who they have.
This is Dara. Is that my computer or hers?
The issue.
I think it's Councilmember Brodsky's connection.
Yeah, so I can help clarify since it appears that
and the guy had to quit.
So Councilmember Brodsky, we're having some issues with your connectivity, it sounds like. But I know she was describing the facts of the Castro Ramirez decision, which certainly, if you qualified for CFRA, you could take CFRA to care for a family member who had a need for it. If you didn't qualify for CFRA, or if you had exhausted your leave, there's a separate question about whether employers have an obligation to reasonably accommodate your need to care for a family member with a disability or an associate, right? If we're talking about associational disability. So that the subcommittee meeting that Councilmember Brodsky is proposing would study that issue.
I'm sorry I lost internet connection there. I think somebody didn't want to hear me talk anymore, which is smart.
So this is Dara. I think this is a very important issue we need to rectify or have a subcommittee take a look at in terms of people being able to take leave to care for someone who has a disability. I would have I think I would urge whoever picks this up to be very careful about just trying to graft the reasonable accommodations for people with disabilities into the statute. There's so much case law, so much of it predicated on the disability itself and the relationship of the disability to the need, and most courts have not extended while you can't discriminate on the basis of association with someone who has a disability. Most courts have not allowed reasonable accommodations to apply to a person who does not have a disability but is an associate, because the analysis under all of the various disability rights laws is so tied to the particular disability of the person and their needs. So I just think we need to be cautious. Whoever does this needs to be very cautious about how this is framed, and in particular, unlike family leave because of a medical illness, disabilities can be lifetime, and so it becomes very tricky. I'm not saying we shouldn't do it. I think it'd be great to have a subcommittee look at the issue. I think it's a problem we need to rectify. I'm just asking people to be cautious about trying to graft reasonable accommodations into this. Not to say we can't do it, but it requires a lot of analysis and rewriting and be thinking?
Well, so I think we, oh, go for it, Councilmember.
I mean, I hate to disagree.
Unfortunately, Councilmember Brodsky, unfortunately, I think we're losing you again. You could try maybe reconnecting or calling in, or now you seem to be there.
I know. I was just going to say, I think the Castro, I don't know what was heard and what wasn't, but in response to Dara's remarks, I agree with the subcommittee will have to do this very thoroughly and well, but the Castro Ramirez court case does provide a lot of guidance and very, and it's, so that would be the framework that the subcommittee could start.
Well, I think there's been kind of 3 potential subcommittees tossed around. We have a lot on our plate already. I think we all agree on that. Doing some real simple math. You're back. Doing some real simple math. If we actually form 3 new subcommittees of 2 people each of us would need to volunteer at least for 1. Having said that, we don't need to form subcommittees on everything right away, given the breadth of what we're working on now. Anyone have any thoughts on kind of prioritizing or you know, want to affirmatively volunteer? We've heard from Councilmember Brodsky for one of the possible subcommittees, and maybe that'll inform how many we form now and how many we defer for consideration in the next meeting.
I just had a thought with regard to follow-up on the anti-bias public hearing. If council members Ortiz and Brodsky are interested in pursuing the follow-up part, I think that'd be fabulous. And here, I'm not sure on the Bagley-Keene issue, I would offer to assist to the degree that if it's not with regard to specific regulations, I can't remember whether it's okay to have a subcommittee of more than 2 if it's not about regulation. So on the part of the follow-up that would involve outreach and trying to coordinate so that there's greater take-up on Ralph and Bain Act claims, whether or not it could be a 3-person subcommittee, in which case I would be happy to help on that. But, you know, I guess the preliminary question is if. So, okay, I see.
Yeah, no, it needs to be 2. I mean, there can certainly be weigh-in at meetings, and it doesn't have to be the same subcommittee that planned the hearing, but we do need to keep the subcommittees to 2.
If Tim, I mean, I would prefer to. I mean, if you wanted to be on that, I would certainly, and Joe does too. And I would like to volunteer to be on this. Let's, for lack of better thing, let's call it the Castro Ramirez subcommittee. I would be happy to.
I think we know where Councilmember Brodsky was going, which was she'd be happy to defer to you or anyone else on the history and hate violence follow-up, and she'd like to form the Castro Ramirez subcommittee. Any other volunteers for a new subcommittee? Any of those 3 or another one? Well, given kind of what's on people's plates and not hearing overwhelming desire to take on more while we still have so much on our plates, I guess maybe we continue to explore UNRU on our own and dive into the case law, but just hold off on forming a subcommittee until our next meeting. And we could still form these 2 subcommittees now that Councilmember Brodsky and Councilmember Iglesias has formed. Are there people that want to join those 2 subcommittees? Of course, nothing prevents Councilmember Brodsky or anyone from doing research and bringing, you know, a proposal or a more fleshed out list of suggestions to the council. So we don't necessarily have to, but if there are people that are interested in joining those two projects, we can form subcommittees.
Could I make another comment, which is Kara, who's just joined us, probably already has a full plate, but I would wonder whether Director Kish might think that there might be some way that she could do some preliminary research on some of these issues that would be either, you know, with the suggestion that a committee be formed to do something, or maybe a suggestion that no, we don't do it, some, you know, whatever. But that's another possibility. But again, I want to respect that she probably comes onto the job and is already overloaded.
Yeah, a memo, especially on UNRU, I think would be on that topic with the UNRU, kind of a comprehensive case law, status of case law thing would certainly be super helpful, whether that's on the department's plate or incumbent on us to kind of pursue.
I do want to flag for the council that in response to council members, hi Adele, we can see you, give us just a second.
I think I'm back.
Okay. In response to council members' previous suggestions, Kara is working on a in-depth literature review of discussions of algorithmic decision-making in employment, housing, and lending, because we are hopeful to be able to hold a public hearing probably early in the new year on this really important issue. So it's not to say no, that we can't continue the UNRU research, but we have obviously some implementation issues to deal with internally as well when it comes to new statutes and regulations that are just coming to being. So I think that when it comes to the UNRU proposal, we can probably continue discussing it internally if the council isn't prepared to form a subcommittee, and revisit the issue at the next meeting.
Kevin, can you just clarify, this is Dara, sure, can you clarify for me, there aren't currently any UNRU regs, are there?
Correct.
So it's not crafting, it may not be as simple as just crafting one provision. There may be, it may be, but it may require, you know, a number of definitional work and a variety of other things that will implicate the rest of the statute. So I just, something to think about.
Yeah, it'll be a big project. Yeah, I mean, I think we would want to tackle UNRU comprehensively, including the issue brought to the speaker, or at least in a phased approach like the housing regulations have gone. Yeah. But certainly we would need some of that background.
We've certainly talked about, yeah, oh, sorry, I thought you were done. Go ahead.
No, I am.
We've certainly talked about that being one of the next big projects we would tackle at some point. And I'm not opposed to doing one or two things that are small bites, but having now tackled two sets of regulations where there weren't any or very old ones, it can be difficult to craft just a single section without understanding the implications of the rest. So I'm not saying we shouldn't do it, but I do agree it might be a big project and one I would love to work on, but I don't feel like I can at the moment given what we expect on the 11135 regs. So.
Well, so I think we'll defer kind of formation. We'll continue thinking about that internally and do our own research and potentially get some assistance from the department on that. But defer formation of a subcommittee to a later meeting. How about, do we have someone that wants to join Councilmember Brodsky on a Castro Ramirez subcommittee or on a Councilmember Iglesias, to the extent he's volunteered, although I don't know that we want to put that on him yet, to a kind of hate violence action item follow-up subcommittee?
If I can, my thought was, you know, we still have the hate violence committee meeting. I don't know that we would be precluded from meeting to kind of unpack the direction, you know, the impact of that committee and the direction we might want to go. We might even have some recommendations for a more narrowed and focused committee on how to respond. I think that might be a better course, that we wait and then Councilmember Brodsky and I talk about what we might recommend going forward.
That sounds fine to me. And then procedure-wise or whatever, if I had thoughts, would it be appropriate for me to address a memo to the entire council, or would it be okay or make sense for me to address a memo to council members Ortiz and Brodsky? So what I'm just looking for sort of direction on what would make sense.
Well, you'd have to communicate with them on the topic of their subcommittee. It would have to be publicly accessible. So you could write a memo that gets posted on the council's page for everyone to see, or you could share them at a council meeting now or at a future one.
Okay, that sounds good. I can do it at a future council meeting, or I'll post a memo, either way.
Okay, so I think we'll keep that subcommittee in place, which leaves Castro Ramirez. Any volunteers to join Dale, or if not, I can spar with Councilmember Brodsky on a presumably complex topic, which is one of my great joys on the council. Okay, I'll join, and we will we'll have some fun on that, Councilmember Brodsky. Okay, so the motion will be to form one new subcommittee on to examine the topic of disability discrimination and accommodations, and in particular the issues raised in the Castro Ramirez decision. I'll move to form that subcommittee.
I second it.
All right. Brian, you want to do a roll call?
Chair Mandelbaum?
Aye.
Councilmember Brodsky?
Aye.
Councilmember Iglesias?
Aye.
Councilmember Ortiz?
Aye.
Councilmember Sandoval?
Aye.
Councilmember Scher?
Aye.
Great. Well, the subcommittee's formed. So we're done with our formal agenda. We do have one agenda item left, and that's a further public comment opportunity for people on a topic of participants choosing some of the related to the council and our agenda items today, or not specifically tethered to an agenda item. So as a reminder, you can email the council, or if you want to address the council directly, probably the easiest thing to do would be to raise your hand, and the meeting administrator, Adam Romero, can gain you the appropriate access to address the council directly.
And I'd also just suggest that given the time and the scheduled close of this meeting, that to the extent there is any public comment, we should probably limit it to 3 minutes for each speaker.
We've got, let's see, yes, it's 12:18. Certainly, I think we need to end by 12:30. I guess with that in mind, let's see how many comments we have. Do we just have, I think we just have, well, Adam, I'll let you guys have access to the email and stuff.
We have one individual with their hand raised, Brenda Labsack. Please let us know if you'd like us to set a time limit.
Let's do, well, if we have one, I think if we have one, I think we can do 5 minutes probably rather than 3. So let's do that.
Brenda Labsack, you are now able to unmute yourself.
Thank you. Can you hear me?
Yes.
Okay,
yeah,
great.
We can hear you.
All right, I just wanted to, they did give a little bit, but they started in the middle of my comment, so it did not provide context. So thank you for this opportunity at the end to give my comment. I am a public school teacher and a former school board member in California, and I would like to address, you already addressed agenda item 7 concerning intentional discrimination, because in July of 2017, I saw that fair housing changed the definition of gender identity to unlimited genders on a spectrum based on a person or a child's feelings or perception. That a person can identify as both genders, neither gender, anything in between, male, female, or transgender. In 2017, fair housing overhauled a social construct of humanity, such as gender, and nothing was said. There was no press release. The media did not cover this. School board members were never told by the California School Board Association. Teachers were never formally notified, and parents are definitely in the dark, especially our immigrant populations. Most people in California find this definition ludicrous and beyond common sense. I read your hearing, and it was the Transgender Law Center in Equality, California, who influenced Fair Housing's decision on this. These are special interest groups. This definition is not based on science, it's science fiction. As a teacher, I have read some of the elementary curriculum about gender identity created by the Human Rights Campaign Welcoming Schools, Advocates for Youth, promoted by the California Department of Education, and it's even in the Black Lives That Matter national curriculum. And I provided you some samples of that from the coloring pages, the books, and the videos from amaze.org in my email. Along with the Southern Poverty Law Center through the 3R curriculum of amaze.org cartoons. So they want to teach our young, impressionable, imaginative, trusting children these concepts. And they are calling it safe and inclusive. It is not safe, it is dangerous, harmful, and exclusive. So why are children being taught concepts in school passed by the Fair Housing Department that parents, school board members, and most teachers have never even heard of? And now you want to entrap us with all of your intentional discrimination definitions, saying that if we do not bow to this horrific definition of gender identity, such as unlimited genders, we are now considered discriminating, harassing, and charged for hate speech. Parents could actually get their children taken away from them by the state due to your actions, because the California Department of Education in their health framework included a definition now called spiritual abuse, meaning that if you don't agree with this definition of gender identity, you could be considered harmful if you use religion as a way to justify yourself. Teachers who do not believe in these imaginary, non-binary genders could lose their jobs by your actions today and your policies. And according to your agenda on number 8, with this new training that you may recommend, or actually, you know, that we're going to feel like we're being brainwashed as employees. As a teacher myself speaking about these unlimited genders and being taught as though they are truth, that they are reality. It terrifies us of all these consequences if we do not adhere to your demands. The ACLU lawyer today here, Fruitwala, you know, I want to quote what they say in their Safe School Coalition, which says, instruction on gender in public schools is not subject to parent notice or opt-out laws. So parents, especially those who cannot afford private education for their children, they have no choice but to subject their children to this indoctrination that assaults biological reality and their religious convictions and cultural mores. Agencies with gender clinics are now partnering with school districts, such as children's hospitals, Planned Parenthood, while the California Teachers Association passed a policy in January 2020 that hormone therapy for kids should not require parent permission for the sake of equity. And Governor Newsom is ready to pass AB 2218, which will fund these gender clinic agencies. It's a lucrative business that they're creating for themselves. They're creating lifelong medical patients out of children, and this does cause sterilization. It's interesting that CTA provided Fair Housing's definition of gender spectrum in their March 2017 magazine. It was actually 4 months before your decision was established. This appears to be collusion between CTA, Equality California, ACLU, Transgender Law Center, and Fair Housing. I'm asking that you please create a press release today so that everyone in the state of California can know this new gender definition that you created in 2017 for us all, and create equitable access of this information to immigrant populations in the state of California in their native tongues. They deserve to know what's being taught to their children under the false facade of anti-bullying, safe, and inclusivity. Thank you.
Thank you for your comments, Brendan, and for the time you took to address the council. You raised, obviously, a very involved debate, really societal debate that covers a lot of different contexts, only a narrow slice of which I think is within the purview of the council. You had mentioned fair housing in 2017. I think you're referring in that context to the housing regulations that we drafted, which mirror the statute, or maybe not, but I do want to point out, and maybe we can get some clarity on fair housing. You know, we're a regulatory body, and our regulations mirror the statutes that they derive from. So leaving aside the kind of societal debate, it's pretty, I think, unambiguous that the California legislature and the governor has signed into law discrimination laws that protect people on the basis of gender identity, gender expression. And so our regulations reflect the language of the statute. I'm not totally clear on the 2017 Fair Housing, what you're referencing, and whether that's something within the council's purview or not.
I can go ahead and email that to you. I can email the link. Would you like me to do that through the chat?
Sure, you can do that, and then members of the council will have that context to understand your remarks.
Okay, thank you very much. I will do that now.
Great. Anyone else wishing to provide comment before we close this up and go have our lunches? All right, hearing no other comments, that adjourns today's meeting. We hope everyone will join us remotely for our November 17th hearing on the use of criminal history and employment decisions. And details regarding our next meeting for regular business will be posted soon, so you can look for that on the council's webpage or join the listserv and it will be emailed to you. So with that, we thank everyone for attending and participating, and have a good rest of your day.
Thanks. Bye-bye.
Thank you.